The next panel
Thank you.
is a global perspective on distressed investing opportunities in both the U.S. and international markets. That's pretty limited, pretty limited agenda. Anyway, it's being headed by the moderator is Bill Brandt, who I think we all know has been a staple of the restructuring industry for, he claims, 45 years, which is it's amazing he's admitted that much. But Bill has been just one of the leaders in restructuring, politics, and just about everything else. So I'll hand it over to Bill.
Thank you, Harold. Well, on a lousy New York weather morning, I think we deserve to look expansively. So I'm going to try and talk a bit about sort of following up on what Steve said. I guess if we were all here 10 years ago, we would be talking about U.S. bankruptcies, and I was struck by Steve's charts that the integration of cross-border stuff is just taken for granted now. And so I think it's probably wise we kick off this morning's panel and if you will, the conference with a discussion of what the future is going to hold. And to do that, I've put together a pretty good panel. I think I've got to my immediate left, your right, Andrew Herenstein, who's one of the machers at MONARCH Alternative Capital, and was telling me that Shopko, just as Steve was discussing it up on his chart, was one of his major investments for this year. To his left is Cecelia Morris, the Chief Judge of the Southern District of New York's Bankruptcy Court. I note that her most recent case was Barney's, which is literally across the street, and seemed to have broken Steve's heart as well. So it's timely that we're in the geographic mix. And finally, I've got Bill Weintraub, who works extensively with me in a lot of cases around the country and around the world from Goodwin Procter. And we've got a kind of a mix of an outlook, if you will, of how this is all playing out internationally, a mix of what the future may hold and the rest of it. I'd like to start with the judge, because I think a lot of us have talked about the fact that there is an international component for virtually every case now. But what a lot of us are not aware of is the judiciary has been thinking about this for a number of years. There are two UNCTAD, that is, United Nations Trade Commission model statutes, both on insolvency and on judgment collections. And there's something recently called the JIN Network, the Judicial Insolvency Network. And it talks about a protocol between the courts. And I think, Judge, I'm going to start off by throwing a softball at you and saying, are the courts prepared worldwide for the growing sort of internationalization of the business?
Thank you, Bill, and that is a softball, but let me give you a little history. Bill talked about UNCTAD, which is the UN trade group. They started back in the 90s trying to develop a model law where everybody came together all worldwide and started to develop this criteria. Well, the United States put that into the law of the country in 2005. Everybody in the rest of the world saw 2005 as the consumer bill, but just slid right in was the UN model law, which has been a godsend to us, and we have it in Chapter 15. All of you know about Chapter 15, and that law, of course, has been very much now, not only is it codified, but we've got a lot of case law on it. And what UNCTAD did was encourage cooperations among the courts to provide and coordinated approaches to administering the assets. So again, you know, if you've got a case in the Cayman Islands, which we have one in the Southern District right now, it's a Chinese hospital chain incorporated in the Cayman Islands, filed for insolvency proceedings in the Caymans, and is now filed to find assets in the United States. That's what this model law is all about. Well, not every government in the world, I think there are only 40, don't hold me to the number of countries that have adopted UNCTAD, but because of that, some countries can't get their governments to pay attention to it, some of the judges. So they got together in Singapore 2 years ago, I guess it's 3 years ago now, 3 years ago, and developed a protocol. And then certain courts adopted that protocol. And it's basically, we will cooperate if at all possible within the law so we will cooperate with each other, and those are the GIN guidelines. Southern Florida, Delaware, and of course Southern District have also adopted those. And then on top of that, we've also tried to get together some memorandums of understanding with courts. Needless to say, those have only been with courts that also have either adopted the UNCITRAL guidelines or the GIN guidelines. So yes, the whole answer to that is yes, but there's something else I need to throw in, particularly for all of you investors. And that is the World Bank has developed a guideline that puts an economic scale, and many of you may be familiar with this. It puts an economic scale on what countries you should be investing in. And one of them is, one of the criteria is, do they have an ability to reorganize? How do they treat their creditors? So is there a reorganization ability, how to treat the creditors? And then the next push that we're seeing at UNCITRAL and worldwide is judgments. Can you enforce a judgment in that country? Now, you think, okay, that may be going on. Judge Marty Glenn of our court is our ambassador, and he is literally worldwide, particularly in the Middle East, teaching people, teaching judges, not people, teaching judges about how you have an insolvency proceeding. So the thing that we tend to look for and we try to concentrate on are all creditors treated, all similarly situated creditors treated equally. So if you're a U.S. creditor, are you treated equally in the foreign jurisdictions court? And can you enforce judgments? And that's where we're going. And last week, I had a whole delegation of Chinese judges at the court.
Well, Your Honor, it seems that there are two things that you're talking about. One is sort of procedural, how courts in different countries coordinate, and one is substantive. What does the law of that other country permit you to do in terms of a restructuring, and can you bind dissenting creditors? Can you enforce a judgment? And would you think that if the law of a country is not as advanced as the U.S., that would promote people looking for the right jurisdiction to have their insolvency proceeding in?
Oh, of course. And I think that's what they're seeing. But they're also beginning to come to the realization that if they don't have some kind of insolvency structure, then they're not going to get investment into their countries. Now, will that hold? You know, I think you look at the United States and you've got the whole history of the rule of law. You look at many other countries and you've got the rule of law, Seoul, Korea, you've got Singapore, you've got many others. And then you begin to see that other jurisdictions will go to those jurisdictions in order to get orders that can be enforced in the United States. How is it that the Southern District of New York has Chinese companies filing Chapter 11 in the United States?
And that was one of the things we wanted to talk about. Judge Chapman of the Southern District defines the term as bankruptcy tourism. So when you're talking about UNCITRAL and the GIN networks, we're not just talking about coordinating Chapter 15 filings where, with the main source of the case, whether it be France or Hong Kong. There is seeming to be competition to get cases filed among these various jurisdictions. Singapore is on a press release, mission from God telling everybody file here. How do you see that playing out, Judge, with all these new rules?
Well, I think it's interesting, and I think, as we just heard from the previous speaker, you just got to watch and see. I think Saudi Arabia trying to put in a insolvency proceeding is very interesting. But how does it actually play out with what you say, the political side of that, when you come to something? What if Aramco has to file bankruptcy? Are they going to really allow any other outside of that country investor have an equal share of what the insider creditors will have? I think we've seen it in South America. You see it quite a few other places. So I think that one's a wait and see, but I can tell you that the judges in those countries are really trying to develop a process that people can come to their court and get a equal bite at the apple. Does it play out that way?
But in some cases, it seems that the reasons they're doing that is precisely because there's perceived to be an increasing competition now internationally for where these cases are housed.
Absolutely.
I did an article not too long ago for the Commercial Law League, and they asked me what I thought the next decade would look like. That is 2030. And I said there's going to be 5 main centers of this activity. They're going to be New York, Delaware, London, Hong Kong, and Singapore. Everybody else will always have their mid-sized and small cases. But the larger cases, there is already a pretty sharp competition among those 5 locales to try and attract the big cases. Singapore, on a mission from God with press releases these days, touting how much they've changed and how much they've become like the States. I'm in Singapore probably once a month these days, and I can tell you the reality is it's still a little slower. The press release leads the reality. But Judge, I think, the Southern District of New York welcomes Chapter 11s from around the world. I mean, you'll take them as you see them, right?
Right, exactly.
And Chapter 15s too.
Absolutely.
Chapter 15s, of
So,
course.
but doesn't this sort of beg the question as to whether or not bankruptcy tourism is a good thing or a bad thing?
Well, are we back to the Delaware and New York debate again?
Well-
We probably could be. I think the EU seems to be predisposed against bankruptcy tourism, but it also has the restructuring directive that tries to incentivize member states to liberalize their laws and aim for something like the U.S. system, so it seems almost schizophrenic.
But if we're talking to a group of investors, aren't we looking at a practicality here? And then the practicality is, where are the assets and where can you get your hands on the assets? And those are going to be those centers.
Speaking
well,
of
not
investors,
just where are the assets, but where can you get the relief that you've bargained for? A lot of these cases start out as what I'll call pre-packs. Some of the recent cases have restructuring support agreements attached to them, and then they file for proceeding in a foreign country and then come here to be recognized to get the orders that were entered in the foreign country recognized and enforced here.
Speaking of investors, one of the thoughts we always have is that somehow, because we always contemplate our navel, we're driving this process. The fact that we're in bankruptcy and we're going to have all these structures set up is somehow what's driving this process. I contend and always have, it's not us, it's the investors. It's where the capital markets are. And the fact that these 5 potential locations of Delaware, New York, Singapore, Hong Kong, and London are perhaps coming to the fore has more to do, I think, with the collection and capital pools available for investments. And so I'm turning to my left to one of the better investors in the world who invests worldwide and says, Andrew, what do you think about this? What about bankruptcy tourism? Is it driven by the courts or is it driven by the investors?
Well, I think there are competing forces at work here, and it really depends on each case who controls the case from the outset. In some cases, there's a strong management and there's a strong board, and they're fighting for control, whether it's for the shareholders or for even their own benefit, and they will determine where the case is filed and where the case is heard. In other cases, creditors take a very aggressive stance early in the case and have a significant influence on the management and on the board and on others as to where a case is heard. I mean, one of the interesting aspects, I think, over the last number of years is there's a lot of increased activism among distressed investors. And one of the things that's led to is an ability to influence various aspects of a case, including where a case is heard, and using aggressive tactics, whether it's trying to force for a scheme in the UK or a scheme in Singapore, or force a case to be in a US court as opposed to in another less friendly jurisdiction. So creditors do play a role, but at the end of the day, they're not the decision makers. They can just use their position to try to influence the process.
But you feel pretty comfortable right now with worldwide investments. I mean, your firm will make an investment in France as easily as it will make one in Hong Kong on the assumption that you can find a way to manage the process and get to a friendly court. It's part of the jurisdictional fights. Is that not the case?
It is. I would say 2 things. We actually have a small investment in Saudi Arabia, which the judge mentioned earlier. but it's small, and we are unbelievably concerned and worried with this investment. It looks cheap, it looks attractive, but rule of law is something that's really concerning. The sponsor, the owner of the company is a sheik who has influence in the country and influence on the process, and it's really opaque for us to try to understand and figure out exactly how it's going to play out. So we have kept it relatively small. Although I did laugh a little bit at the concept of rule of law, because fundamentally it is what our business is about. We don't make investments in China. We don't make investments in Russia. We don't make investments where we can't rely on the courts to make sure that the credit agreement is implemented as it's written. But I would say that we've even gotten concerned about rule of law in the United States. Over the last 10 years, there's been a number of examples where we've sort of veered from the rule of law, whether it's back in the time of the great financial crisis with Chrysler, or even cases in Detroit and Puerto Rico, and even PG&E. One of the interesting aspects is that there's been a lot of politics. A lot of the cases that we're involved with these days have politics surrounding them. And whenever politics gets involved, it's a whole nother degree of influence.
That's P-O-L-I. Let me just make sure I got that.
Exactly.
So, so what's your fear of the politics? I mean, you guys you have a long history. You've been at Lazard. You know politics as well as anybody else. What's your fear of this? Why don't you get in and fight with the rest of them?
So when you have one creditor lined up against another creditor, you have a bank lined up against a bond. They're both economic animals, and at the end of the day, the law will be what the law will be, and the system will play out, and one side will win, one side will lose, both sides will lose, however it plays out. But when you have creditors that are not real economic animals, like a pension fund, for example, it dramatically complicates things. Both from a public relations perspective, it's much harder for an investor for a fund investor to challenge when you have the people on the other side, through no fault of their own, are put in a very, very difficult situation. They're pensioners where they've been promised something, where their claim, legally may be inferior to the claim of a financial creditor, but it's hard for the financial creditor to assert from a public relations perspective. And if a government gets involved and says, we're going to make sure that pensioner is taken care of, and whether it's changing the law or interpreting the law or putting in place strategies that make it harder at the end of the day for financial creditors to succeed, that makes these restructurings more challenging.
Not to veer too far away from the international aspect, the political aspect is important. It's important here, it's important anywhere. Perhaps a case in point, and I'm biased because I was involved in it, is General Motors, where a sale was done at breakneck speed, and then years later it turned out that there was a serious undisclosed defect in millions of automobiles. And now the bankruptcy court, through two judges, because one judge retired and another judge took his place, has been dealing with litigation resulting from the violations that were a byproduct, I think, of political pressure.
But I think that's what Andrew was talking about. I mean, General Motors just didn't file a Chapter 11. There was almost a whole political creation done around this case that had nothing to do with the strict economics of it, which caused a lot of people, just like Chrysler, to suggest that the playing field was being heavily tilted by government intervention. If that's the case, Andrew, doesn't the funds, don't you also engage in the press aspects of it, get involved in the politics, or do you pull back or do you go forward? What do you do?
So, first of all, I think it's fund by fund. It depends not only on who the fund managers are, it depends whose capital it is. I mean, what's really complicated is a lot of the capital that private equity funds and hedge funds manage is for pension funds.
Right.
And so it's sort of awkward in that in some sense you're arguing, why should this pension fund benefit at the expense of this pension fund? So it is a complicated issue. Going back to the question earlier about investing in other locales like France, for example, France is a really difficult place to invest. It's a market that favors favors labor over capital. And from my perspective, we've been investing in France for 25 years. We've made...
And that's mostly because of the food, or that since it's so tough? Why do you do it then?
There's amazing kosher French food, let me tell you. There's there's a lot of experience that comes with it. I spent 50% of my life in 94 and 95 traveling between London, Paris, and Tokyo, working on the restructurings of Eurotunnel and Euro Disney. And with that comes a tremendous amount of experience. And those were done out of court. And I would say that 80% of the restructurings that we've done in France have been done out of court because the court structure is so difficult to work within. And all parties, management, even shareholders, and certainly banks, have found that it's a better result for all parties if the restructuring can be done out of court. And we've become relatively adept at working through that system. Obviously, you've got to make sure you buy it right. Obviously, you need to make sure that you are part of the system, that you speak French, and that people are comfortable with you. Because if they're not, if you're viewed as just a foreign element, it's very, very difficult to play within that system.
So
So
partly with
how do
bankruptcy.
you bind dissenters in a system like that? Do you have to wait until you can tie a bow around it and you've got everybody, or you're just going to have to deal with some leakage?
It depends on the case, but the answer is both.
So the EU has put out a directive, which Bill referred to earlier, where on the cusp of Brexit, the EU had realized that all of a sudden you could have a number of continental operations filing again and making the UK a center. So they directed every remaining member state to come up with a program, a restructuring program that mirrors to some extent sort of a bastardized Chapter 11 and a bit of the English scheme of arrangement. Given that, I mean, what's your outlook for that in terms of your investments in France and the others? Do you think that's still going to present you a problem on a country-by-country basis, or will the EU uniformity help you a bit?
Well, again, the EU hasn't made any laws. They've issued a directive.
Right.
And that directive is going to be taken up by a whole bunch of different states. And the likelihood that all those states are going to do the same thing, exactly the same thing, remains remote in my mind. And we'll probably have a whole bunch of countries moving towards a system that looks a little bit more like the U.S., a little bit more like the U.K., but I still think there's going to be distinctive restructuring regimes in each of these locales, and investors are going to have to get comfortable dealing within different regimes. I mean, we made an investment in the last couple of years in a company called Agricor, which is based in Croatia, and it was really our first investment in that country. And the work we did not only revolved around valuation, is our debt that we are buying covered by the assets, etc., but it was also studying the legal system. Are we comfortable with the sustainability, the robustness of this legal system? And what made it more difficult is that when we made the investment, Croatia did not have a strong bankruptcy process that we were comfortable with, but this company was so big, it was essentially too big to fail. It was the largest employer in Croatia that they passed a new law during the case. And we dubbed it Lex Agricor. Essentially, the law was designed to save Agricor and save jobs. And
Let me ask you a question on that one then. Would that then be recognized in the United States as a Chapter 15 if it were only adopted for that one case?
so I'm not 100% sure it was adopted for that one case. I believe that it can be used for other cases. I'm just saying that
That
it
might have
was-
been the impetus, in other
It was
words.
the
Well,
impetus for making
but-
for making-
In Judge Glenn's
Judge-
opinion in that case, he did comment that, if it were just for this company, it might have presented a problem in recognition, but the way it was written, it had application to other companies.
So let me come back around the shrubbery for a second to explain. Agricor actually filed a 15 here in the SDNY. Judge Glenn got it. He's written a decision that's sort of reverberating around the world these days. And Judge Morris, I mean, as you say, he's your international go-to guy. What do you think of the Agricor decision, if you can speak on it before we go further?
I passed a bill.
So,
Well, certainly it's a tour de force.
Well, but I want
in terms-
to ask one more question of the judge. So I heard Andrew talk about politics in cases, and obviously you've had more than a bit of experience with that. Without getting off on the deep end, I mean, how do judges deal with the political aspects of cases when it's clear that some of the folks in front of them are bringing leverage, if you will, that's not just strictly economic?
Well, I think what you have to do is, it's not case by case, and it doesn't necessarily slant you. But I will tell you, the pension funds do have a soft spot in every judge's heart. Now, do we know what's going on behind that? No, we don't. You may be in there arguing for the pension fund, but you're always arguing for that guy needs it. Well, do I know if that guy's actually getting it or not? No, I don't. So there is always, always, always a soft spot for an employee and the pension. There's a soft spot. Whether we rule in their favor or not will depend on what the case law is and what's going on. Now, when you talked about GM and Chrysler, we've all read the book. We all know what sort of went on behind the scenes. You didn't see that necessarily in front of you, except it was, again, I mediate a lot of cases. You don't necessarily see my name on the big 11s. I'm so often behind the scenes on mediation, and I see sometimes who's at the table that you will not see in the courtroom. And that's when you begin to see some of these influences that you as a judge, remember, the iceberg, we're at the tip of that iceberg. We're not underneath. We don't see all that's going on that you see. We don't see that.
So talking about Agricor again, just for a second, that when I talked about the 5 locales that may be the source of this business in the future, each one of them, if you look at it this way, has a certain infirmity that goes with them right now that has to be dealt with. For example, in Hong Kong, there's an appellate court decision called Legends. And Legends stands for the proposition that, frankly, you can't do a financial restructuring in Hong Kong with the joint provisional liquidators, because the law has determined that joint provisional liquidators can only liquidate the company. Jonathan Harris, who is the justice who oversees most of the bankruptcies in Hong Kong, and I'm in Hong Kong these days 2 to 3 times a month, unfortunately, is trying to figure out a way to work with Beijing to get rid of that or legislate around it in competition with Singapore, because he sees what's coming. In England, there's something called the Gibbs decision, which is our opening for Agricor. And the Gibbs decision basically says that you can't compromise debt created in England in any other form other than in an English court. And that, to me, was the crux of what happened in Agricor, Andrew and Bill. And can you talk about that case a bit and talk about what Judge Glenn did? Because he sort of put England on double secret probation, if I can put it that
Sure.
way.
So what Judge Glenn did was, in basically an unopposed recognition motion, he wrote a 55-page decision supporting recognition and supporting his approval of the settlement agreement that was entered into in the Croatian proceeding. He basically limited the effect of his decision to the 9 entities that actually filed for Chapter 15 relief in the U.S. Agricor was much bigger than that. It was 155 companies in the group, only 77 of which were based in Croatia, and 80 of the companies did not seek restructuring under the Croatian law. So there was quite a bit of
Right.
slippage. First of all, Judge Glenn looked at the law and, as I said earlier, recognized it as a foreign main proceeding because it had the attributes of creditor participation, creditor voting, access to information, notice, and all of that. He then looked at the question of would he enforce the scheme or the settlement agreement, and observed that, number one, several countries did not recognize the Croatian law as an insolvency proceeding that they would recognize. The UK did, but it did not determine yet whether or not it would enforce the settlement agreement. So Judge Glenn, on balance, looking at the Croatian law, the attributes of it, recognized it. Then he had to determine whether or not he would approve the enforcement in the U.S. as to the 9 debtors of the agreement. The key part of the agreement were third-party releases for guarantor entities, and he went through an analysis of why he was going to approve it, and that even though third-party releases were controversial in some jurisdictions in the U.S., permitted under limited circumstances in the Second Circuit, he would nevertheless approve the enforcement of those releases of the guarantees because they were not inimical to U.S. law. He then had to deal with the Gibbs rule. And he recognized that because a lot of the debt was issued under UK law, if the UK courts enforced the Gibbs rule, it would scuttle the restructuring.
And we ought to just pause. The Gibbs rule is actually a case. It's an appellate case from 1890. And so actually Bill was there on scene. I think you were in the courtroom, as I recall, during
I was the lone objector.
there you go. So Andrew was funding the other side, but he was just young at that point. So the Gibbs rule, it's a case, but it turned out to be the Gibbs rule because basically it stands for the proposition, and you run into this in the Caymans and the BVI and every place else, that you can't compromise debt for English creditors in any other form other than an English court, which is a problem for Judge Glenn.
Right. So as I said, Judge Glenn observed that if the English court enforced the Gibbs rule, it would scuttle the restructuring. Nonetheless, he went through an analysis and he decided two things. Well, really one thing, which was he was going to enforce the restructuring in the U.S. and it was up to the U.K. to do whatever it wanted to do. He started down the rabbit hole, but I think more as an academic exercise of looking at comedy and saying, well, I need to give comedy to the Croatian proceeding, but do I also need to give comedy to English law? English law would undermine the Croatian proceeding, so who should I give comedy to? He decided I'm not going there. The only thing I've been asked to do is whether or not I'm going to recognize and approve this Croatian restructuring. That's a matter of U.S. interpretation, U.S. enforcement, so I'm not going to bother with UK law. But then, in the last part of his opinion, he has an academic discourse
He waxes eloquently, I believe, yes.
as to what's wrong with the Gibbs rule. And in a nutshell,
sometimes we just need a forum.
Exactly. So I don't know if it's a shot across the bow or just a helping hand to our friends across the pond. But he said two things. Number one, this is an anachronistic parochial rule that is inconsistent with the cooperation that we need to do internationally. It doesn't comport with what we're trying to do under the model law. Number two, the premise of the law seems to be, or the rule seems to be flawed because it's based upon contract law. It says if your document says that your debt is governed by UK law, therefore only a UK court can adjust or discharge UK debt. What Judge Glenn says is that's not true in a bankruptcy proceeding. In a bankruptcy proceeding, contracts always bend to insolvency law. So the underpinning of the Gibbs rule doesn't make sense in an insolvency regime. So as to what may happen, Judge Glenn approved the settlement contingent upon what happened in Croatia. There were 191 appeals from the lower court's determination. All of those appeals miraculously were resolved in favor of the debtor, so that issue has gone away. So the condition has been removed, and it's now up to the English court to decide what it's going to do.
So I want to talk about bankruptcy tourism one more time, going the other direction. So here we are in SDNY thinking that a lot of these folks, because of the American rule of law, are not only going to file their 15s here, but more and more they're going to file their 11s here if they can figure out a way to do it.
Since we're up 200% in the Southern District of New York.
We are up
in
200%.
Chapter 11s.
But here's an oddity. Just recently, a case called Syncrian, at least if you believe the press release, decided that filing a case in the U.S. was too expensive. And so, Bill, as I understand it, they chose to file a case that should have been filed by any other measure here. They actually decided they would adopt the English scheme of arrangement and take a U.S. case and file it there.
That's right. This was a company that was arguably domiciled and headquartered in the United States, but it had an international footprint. It was involved in logistics and supply chain advice and technology for the automotive industry and the tech industry, and it seemed to be some kind of a roll-up or a merger of companies, and it was over-leveraged and in need of restructuring. And the decision was made to put only 2 of 30 companies into English schemes of arrangement in England. And basically, the argument was made that it's cheaper and it's faster to do it in the UK. And I guess, although not discussed anywhere, because there's not really a written opinion on this, the notion would be, because it's really not a judicial proceeding, it's a quasi-judicial proceeding, that unlike a situation with a failed pre-PAC where the court won't confirm it and you're stuck in Chapter 11, in the scheme of arrangement, you're not in an insolvency proceeding per
Right.
se. You're just trying to get the creditors to vote for your scheme of arrangement, which is approved by a court that supervises the voting and is ultimately an order approving it, but it's sort of a hybrid proceeding. So the case went ahead in the UK and then landed in the US, and the bankruptcy court in Delaware was asked to basically recognize the scheme of arrangement or the scheme of arrangement proceeding, which is under the Companies Act under UK law, and it's not a bankruptcy proceeding per se, but it's got the flexibility to be used to restructure debt. So the court found, and courts in the Southern District have also found, that schemes of arrangement are a qualified proceeding for recognition. So the court recognized the scheme as a foreign main proceeding and proceeded to approve everything that was done in that proceeding, which basically converted most of the senior secured debt to equity, left them with about $225 million of secured debt, converted U.S. notes to mostly to equity, and restructured some of the other debt. One of the things that I forgot to mention was that the governing law of some of the debt was U.S. law.
And so we were going to talk about this earlier. When we talk about cases filing here that perhaps don't belong here, at least from other perspectives, a lot of the bonds are issued under New York indentures, or there are bank accounts in the U.S., and so you can find a hook to file an 11 here. In Syncrion, they actually had bonds issued under New York law, and now what are they going to do?
They amended the documents to make them covered by UK law as opposed to New York law, which gave them the entry to the UK proceeding.
Let me interject one little thing right here, because it goes along with the case that Bill's talking about, and that is UNCITRAL has just adopted a model where it's the enterprise. And it seems to me, if they were following the UNCITRAL, the enterprise in the UK court would be legit, because it's part of the entire enterprise. So that's, and of course our Congress has no stomach for doing anything with bankruptcy right now, because it would be too much going on. But there is now a model enterprise definition, so that it would cover something like that.
Now, one of the interesting things that I noticed in the case, and I didn't have access to everything in Agricor and everything in Syncrion, or I had access, but it was way too much for me to read, was that in Agricor, only 9 entities filed for Chapter 15 in the U.S., and Judge Glenn would only protect those entities that filed for Chapter 15. In Syncrion, there were at least 30 other entities, including the U.S. entity, and none of them filed. And the way I read what the court did was it protected all of them, even though they were not part of the Chapter 15 proceeding, which is interesting. And I don't know what that really means at the end of the day for how good the protection is.
Well, I mean, that gets to the issue of the worldwide stay, the extraterritoriality issue, which is one of the biggest problems we're running into. I mean, Andrew, I know that you had some thoughts on Agricor too, and the fact that it was Judge Glenn's decision and the rest of it. I think, what's the investor viewpoint on Agricor? How do you feel about this?
So, I'm not a lawyer. I'm a little bit out of place in a certain sense.
No,
Although-
this is 2 lawyers and 2 regular people. That's okay.
Although I do spend most of my day talking to lawyers.
So you're not a lawyer, but you
sorry.
play one on TV. Is
Sorry
that
for
it?
you.
Right.
So the truth is that the issues that you're talking about, I mean, in some ways are fundamental to the case, but in other ways are just sort of details that many bankruptcies.
Whoa. Details. I mean, are they details you think about before that you invest, or details you think about after you invest?
So what I was going to say is that in many cases where we invest, there's a tremendous amount of opaqueness. It's hard to know, in some ways we're outsiders, and it's hard to know exactly what the company is doing and exactly, from a business perspective, we don't have perfect information. From a legal perspective, we don't have perfect information. And so you're sort of putting together a mosaic, trying to understand, if you buy a certain loan or a certain security within the capital structure, what is the potential upside and what are the potential risks? And to my mind, those are one of the risks, that you think you're in a proceeding that's stable and where there's a path to clarity and where you can ultimately get a recovery, but it's possible that it goes off the rails and some other court intervenes or you don't get the protections you need. But for the most part, I look at something like that and say the likelihood of this totally collapsing and liquidating because these courts can't figure out how it's going to play out is pretty de minimis. I don't know exactly what the path is going to be, how we're going to get there. But as an investor who has a lot of experience, who's been involved in hundreds or thousands of cases, I have a general understanding that these things get done because it's better for society and it's better for the creditors and it's better for the employees for that to happen. It's ultimately we get to a path. Sometimes we don't. Sometimes we get to a liquidation and things don't work out and it's a bad result. But we made an assessment in that case that the most likely outcome, without knowing exactly what the path was going to be, was that this was going to work through a Croatian system and there would not be interference from foreign courts.
Okay. Judge, I'm going to come back to you for a second and talk about the fact that bankruptcy tourism is real and it exists. And there's a seemingly strong debate over if somebody wants to file a Chapter 11 in the United States, what constitutes significant nexus with the United States? Delaware argues, I think, for a far more formal version of nexus, you've got to have some operations. It appears just from the literature that SDNY, if the bonds are basically domiciled here, or if you've got bank accounts or retainers are paid, what's your view on that? How easy should the access be to the U.S.?
Well, case-by-case basis.
Well, sure.
But I think if you're needing to interpret U.S. law and you've got an asset in the United States, I probably would be inclined. It would be according to what they were arguing. Are we completely off the record?
Absolutely. Even all the reporters here are saying that.
Completely.
Come on,
All right,
Alexander.
everybody, I want you to know this is off the record. But it would seem to me you're looking at an individual case-by-case basis. And if you know that the jurisdiction in which this company would possibly have venue would not be a reorganizing venue at all, and you could not get equal treatment for the creditors, you would be inclined, and again, completely off the record.
Well, wait a second, though. What we've been talking about here is the rule of law and the other issues. It is clear to me, as Andrew discusses it, that creditors in big-time cases figure they're getting a better shake under U.S. law because of the predictability, because of the long structure. If somebody seeks refuge in SDNY, and it's clearly, under the structure, you're going to apportion the pain equally among the creditors. Do you, just off the record, do you work to find a way to keep the case, or how do you see it going on a case-by-case basis?
I think we work to keep the case.
Okay.
But just not to be the dog in the manger.
No, go right ahead.
You only see what the creditors permit you to see.
Exactly. And you, or what the debtor shows us, or what
Right.
the creditor. Remember, let's go back, and that's why this is completely off the record. Let's go back to that iceberg. You're arguing in front of me in court, and people may say, did you read the news account? We really do try to avoid the news accounts because that's not what's in front of us. And in fact, I read a news account this morning of something, and I went, did I do that? So you don't necessarily believe, the judge doesn't. You've got to know what's being argued in front of you. And if they're coming in saying they've got nexus here, nexus there, who's objecting? Are you objecting, Bill?
Well, not to pick on Agricor, but it's just a fascinating case. So Judge Glenn wrote a 55-page opinion. There's one sentence in that opinion that says, I previously recognized this proceeding in a separate order, so I'm not going to repeat it here. Being curious, I went and looked at the order. It was an 8-page form order that just basically made findings that it was a qualified proceeding. There was no discussion as to what the nexus was at all. Now, I'm sure at the hearing it was discussed, and perhaps in the moving papers it was discussed, but there was nothing in the order and there was nothing in the opinion.
Okay, I can't speak for Judge Glenn, but I can speak for myself on when I write an opinion. I write an opinion for various reasons. The first reason is I need to educate my lawyers in front of me. That's just, they're in front of me. They need to know this is the way I think so that we've got the future, you understand it. The next thing you write for is, and I write them on two different levels. Most of my opinion, all of my, not all of them, but most of them go to White Plains, and there is some wonderful district court judges there, but Kathy is a good friend, and so I say, Dear Kathy. Oh, how I hate to write. And that's how I think when I'm writing the opinion. Every once in a while, you'll say, Dear Sonia. Oh, how I hate to write. But you need to know what I'm thinking, knowing full well that it'll go through different stages. So I can't speak for Judge Glenn, but maybe that was why the opinion was written. Maybe there was something brought up in the courtroom that made him think it was either going up on appeal or he needed to clarify to the lawyers in front of him. Please, I do not speak for Judge Glenn, and I will not speak for Judge Glenn. In fact, I'll let him speak for me because I think he's an amazing judge.
He's great.
So-
Going back to your original question, Bill, certainly in the Southern District, the nexus can be extremely tenuous. It could be a retainer paid to the law firm to bring the Chapter 15 case, and that gives you the property in the U.S. And then, that is certainly the tail wagging the dog, and it's bankruptcy tourism on steroids.
Well, but you also have to recognize, I'm about to go to Andrew next, that for the purposes of bankruptcy tourism, when you sit down and you think about venue, as we all are discussing here, basically among any locale in the world, Delaware seems to have a harsher sort of case law perspective as to what constitutes a nexus to the United States. So when you're thinking about where to file, SDNY appears to be more welcoming, perhaps because it's the capital of the world, but more welcoming to overseas debtors.
And most debt is governed, but most U.S. issued funded debt is governed by New York law. But technically, you could file a Chapter 15 in any bankruptcy court in the country, I think.
You could. You could. Andrew, I mean, you're reading press release after press release about how Singapore is the wave of the future. You've talked about the issues in France. I mean, how do you see the world in terms of where this is going and where you'd prefer to file a case versus where you think there's still some time that needs to be worked through before cases are ready to be filed there?
So the truth is, I don't really file cases.
That's true.
I'm not the debtor.
But you have a
But
preference.
even as a creditor, I may not be the largest creditor or even involved in the case.
But I know
when the
you're not.
company is filed.
But you're not a shy and retiring personality. That distressed fund and shy and retiring seem to be an oxymoron. So I know that you've been in a few meetings with you where you have an opinion often.
But again, let me sort of describe a case that we're involved with that you're very familiar with. A company called China Fishery, where we actually did not. This is a company that has parent entities in China and Hong Kong and Singapore. The actual business is based in Peru, and there's virtually no nexus to the United States. But one of the bonds was issued in New York, and so they were able to file for Chapter 11 in New York. I would never have invested in that company prior to a Chapter 11 filing. I would never have invested in that company assuming that I'm going to go down to Peru and try to figure out how to work through that process, which is not creditor friendly, not easy to work with. So many times, just directly to your question, I'm not even involved in the case at the time the decision is being made. We're coming in as an investor, looking at it and saying, well, this is an interesting company, but I can't invest in this company because I'm not comfortable with the jurisdiction. And then something happens, whether the Agricor case happens and it becomes clearer that the jurisdiction is going to stay in Croatia, or the China fish case happens and they somehow file for Chapter 11 and it gets accepted, and all of a sudden it's now in a jurisdiction that we're comfortable with and that we can make an investment in. And so it's a little bit tricky from that perspective.
But as I look at this, and we had this discussion just earlier briefly, So you're making a decision whether to invest. I assume that decision, opportunities float across your desk. It's the economics of the deal that attract you first. Or is it part of the decision also the jurisdiction? I mean, when do you bring the jurisdictional issues in? After you've decided that the case is worth a second look? Or how do you do it?
It's all integrated because you don't look at reward without risk, right? The two of them are sort of connected at the hip. And part of risk is what's the jurisdiction, what's the certainty, is there an outcome that you can sort of guess to or work to or a likely outcome that you can invest upon, and the jurisdiction helps you get comfortable with that. If there's no jurisdiction or it's an uncertain jurisdiction or a bad jurisdiction, then a 15 or 20% rate of return may not be sufficient to compensate you for the risk that you're taking, that this thing could devolve into something really ugly or take 3 or 5 years, and instead of a 20% return, you get a 5% return or you get a loss. So to me, they're all integrated, and what the jurisdiction is critically important as part of the overall analysis.
So as part of the team when you do this, I mean, looking down the table at Bill, do you bring in counsel early on when you're making your distressed investment decision to determine just what your options could be to steer this thing somewhere? Is that part of the process, or do you only engage with counsel after the fact?
So I think we talk to counsel early in every case. We want to make sure we understand all the issues. We want to understand them before we make an investment, not after we make an investment. And in terms of steering a case one way or the other, again, that's relatively light in terms of what we do, although there are cases, there are circumstances where we get involved and it's difficult and it's challenging to find a path, and maybe there's another jurisdiction where maybe you can do a scheme like they did in Syncreon, although again in that case it was done early on. But there are circumstances where we try to figure out exactly what to try to change the path if the path we're on is not working.
But if you're not leading the charge, and I'm not completely familiar with how you do it, do you look to see who else is in the group, because you've got people in the group that know how to lead the charge?
100%. In virtually every case that we're involved with, there's a group of lenders, and generally those lenders work together. They hire one counsel, they hire one financial advisor, and they work together to try to move the case forward. So we may only own 5% or 10% or 20%, but we're part of a I don't know if I can use the word group in certain circumstances.
Syndicate.
But we're part of a syndicate
Yeah,
that may own 50% or 70%, and that syndicate tries to influence the process. By the way, it's a whole nother ballgame, because the syndicate may look like one combined entity, but many times there's a lot of infighting within the syndicate.
Sure.
To try to move that ball forward with a lot of aggressive and people with a lot of different views is not easy in and of itself.
So, Bill, one of the things we were talking about earlier, based on what Andrew was just saying, so you understand the funds and you understand the distressed buyers, but when this all drags along and winds up filing something in the U.S., there's a lot of international creditors who aren't used to the U.S. system and aren't used to the whole process. I mean, are you seeing these larger creditors getting more comfortable with the process, or is there still some resistance based on the Comey issues? How do you see that playing out?
Well, I actually don't do much with foreign creditors, so I could only sort of analogize to what I've seen in some of the retail cases where the supply chain is offshore.
Right.
And the necessity for taking care of those people or those suppliers on the theory that they don't understand U.S. law, they don't understand the automatic stay, and they will cut us off, and then we will have to go to those jurisdictions. So I would think that it's sort of the same story, but
It's much like the capital restructurings we see in Delaware, where you realize that the trade creditors are such a small piece of the action that if you can't really call them critical vendors, but if you don't deal with them and push them off to the side, you're not going to get a larger outcome. Is that your take on it too, Andrew?
For sure, although sometimes these foreign creditors are unsophisticated and don't understand U.S. processes. Sometimes they can just act that way in order to take advantage and get paid off in full.
But
so
for the most
it's
part,
hard to differentiate between the two.
For the most part, the debt for borrowed money is it's U.S.-based or UK-based, so you're dealing with sophisticated. And it's the trade, even in these foreign entities, that need to be dealt with. And I think it was in Syncreon, they were all taken care of. They were unaffected.
unaffected is a nice word, yes.
Yeah.
In other words, basically covered,
Right.
as they say. Judge, how about you? I mean, you see a lot of cases coming into SDNY with a lot of foreign creditors. I mean, do the judges, in your opinion, take extra time to make sure that the creditors who are not usually seen in U.S. courts feel comfortable with the process?
I think the wisest thing that any judge can say at any time is, you need U.S. representation.
That's not a bad idea either.
Yeah.
So we
Just let me just say, actually an individual consumer case, I had a creditor fly in from China. And the only thing...
individual consumer case?
And the only thing I could keep saying to him was, you need U.S. representation. You need U.S. representation. Because it was, he had a claim. He didn't understand that you had to go through a process with the claim. He thought he could just come to court and wave his papers in front of me, and it can't be done.
So speaking of the PRC, China, Andrew, you were mentioning that while you invest in Hong Kong and other areas, China is still a bit off limits. How do you see that? And why do you see that?
I mean, I think there's two elements, or three elements for us. First of all, at the moment we don't have an office in Asia.
Okay.
We have an office in Europe and in the U.S., but from a time zone perspective, it's challenging. From a language perspective, it's challenging, and from a legal perspective, it's challenging. We are still not comfortable with rule of law in China when it comes to the Chinese restructuring processes, and the truth is, they're just really gaining speed. We've just seen, I think, the leading edge of that. We think there's going to be a lot more restructurings in China over the next number of years, and we continue to look at that and reevaluate it. But for the moment, we have enough to keep us busy in the U.S. and in Europe and in South America and in Australia, for that matter, that we don't have to go and take risks that we're not currently comfortable with.
And Judge, in terms of the Chinese getting up to speed, you've been giving a lot of tours. I think the judges from Shenzhen were here just last week, which is, of course, the megalopolis just adjacent to Hong Kong on the other side. And they may have one of the more advanced court systems for this, from what you're
And
seeing.
what they're trying to do is trying to understand our process, and they're really working at it. And just let me say something. Beginning in the 90s, when the first UNCA trials were meeting, the Chinese would send a delegation to observe.
Right.
And they have now become much more active. And I at least every 6 months, we have a Chinese delegation come in to try to understand. I think one of the things, though, that started it was the Chinese investor. A lot of these companies that come in have Chinese investors, and that's what started them looking at a process.
Well, I think I'm getting notice that our time is up. Don't know if there's any questions out there. We could probably take one or so before we break. Any questions? Yes, Alejandra. Hang on a second. So,
You see that standard kind of any company coming to the U.S. and filing a bankruptcy, is that changing anytime soon, or do you think that's kind of going to stay the same in terms of foreign companies?
I think actually it's going to become more prevalent. That's just me speaking. I think that's the sense of the panel. But I think there's going to be a competition among a lot of locales to see if they can attract that business. So you're asking if you think they're going to continue to file and increase? Yeah. What does the panel say?
Based upon your recent experience, absolutely. The two cases we talked about today are prime examples of people coming to the U.S. to get their arrangements in foreign courts validated in the U.S. And there's significant interaction with the U.S. given where the debt has been issued and the composition of the creditors. So I think absolutely.
Andrew, you think the same?
I mean, I do in one sense, but what we've talked about is Singapore changing its laws and changing its procedures to try to attract companies to restructure there, and the EU directive is trying to change what they do to essentially which will have the effect of keeping some European companies restructuring in Europe. And so while for a long time the U.S. was the predominant place to restructure, either the U.S. or the U.K., because the system was manageable, I think there's a chance that other countries and other systems become more like our system, and that will encourage people to stay a little bit more local.
And
Judge?
don't discount India, because India just passed their first complete country law, so national law, And I will say, I was on a trip to Africa, and I met with some business lawyers there, commercial lawyers there, and they were talking about if they take a proceeding, it would not be to Europe, it would be to India.
So from my perspective, shades of Delaware and New York back in the 1990s in the competition. I think you're going to see, Alexander, 5 main centers, as I said, develop: Delaware, New York, London, Singapore, and Hong Kong. There's going to be action in India and all the other locales, but these cases are going to compete, or these locales are going to compete for cases. In the Syncrian case, I mean, it goes both ways. Here's a case that should have been filed here, and it goes to London simply because folks thought through the venue issues and how it worked fastest, and that's where they filed it.
Well, and of cour-
But then they had to come here.
They had to come here, right.
In addition to that scheme being effective, they needed to come to both the U.S. and to Canada to get
But
the schemes approved in
But
both
it's a question
jurisdictions.
of where they start, isn't it?
Exactly, and it's a lot less work for the U.S. lawyers in Syncrion than it was for the U.K. lawyers.
Well, and I think Seoul is also trying to compete
Yep.
with Singapore. And there was a Singapore case that filed in Seoul and then came for Chapter 15 recognition in Southern District, and the Singapore creditors came to protest. Judge Drain said it's a legitimate filing in Seoul,
Yeah.
turned them down.
You know, from a practitioner standpoint in SDNY, my favorite 4-letter F word is fees. So I'm always happy to see people show up here and practice, and I'm assuming we'll be an attractive locale for years to come. But I absolutely understand there is competition out there to attract those cases, and it's going to become more intense in the coming years.
By the way, that's my least favorite four-letter F word.
And I think many people in the world are aware that the fees in any U.S. Litigation is dramatically high.
That Syncrian apparently was filed for one reason, and that was they thought the cost of a
Keep
loan
the
would be
fees
too
down, but
expensive.
But
Yeah.
they also did go through an extensive
Well,
pre-scheme process with an RSA, just like we do here.
Who would have ever thought that London would be cheaper than New York for fees? I mean, this is where the world is getting these days.
It's pretty ironic when you think about it.
Yeah, it is. And with that, I think we'll wind it up. I thank you all for being in attendance this morning, and I hope we were entertaining.
And please don't quote me. Anywhere. Well, always fun to see you.
Thank you. Good seeing you. Nice job. Thank you.
Nice to meet you. I see all your emails.